Good afternoon, everyone, and welcome to the Law and Crime Network. I'm Misty Maris, and I will be your host this afternoon. This morning, we were live in the William Knight trial. We heard the openings by the prosecution and the defense. Now, while court is on a break, they're at lunch, which will resume around 12:30 p.m. Eastern Standard Time. We're rewatching a trial that we covered 2 weeks ago. This is the Leon Jacob trial. Now, this trial had so many twists and turns. So just for those of you turning in to review the gist of this case, this was a murder for hire plot. We were just watching Leon Jacobs actually testifying on the stand, telling his side of the story. Now, interestingly enough, after the verdict in this case, a lot of jurors' opinions was, look, we were not sold on his testimony, and that's why we convicted. So I want to bring in Andell Brown. He's a criminal defense attorney to really break this case down. Andell, thank you so much for joining us today. We really appreciate it.
Thanks for having me, Misty. It's always a pleasure.
Absolutely. So, look, we have a lot to cover today. We're going to be talking about the Knight case as soon as they get back from break, and we're going to be live in that trial today. But in the meantime, I really want to talk about the Leon Jacob trial. So this was such an interesting case because you had a murder for hire plot. You had Leon Jacob paying an undercover police officer to actually facilitate those murders. And we also had a photograph of the police actually staging this murder and getting a reaction out of the defendant. So there's a lot of twists and turns here. But what I would like to ask you about, Andell, because you're a criminal defense attorney, what did you think about Leon Jacobs' testimony? Do you think that helped him at all?
I don't think it helped them at all, Misty, but I don't think they had much of a choice. I mean, look at the facts of this case. This has all the makings of a Lifetime movie. You know, you have the doctor who's trying to get rid of the ex-girlfriend that was abused with his new girlfriend, and then they throw into the mix that they're going to get rid of her ex-husband while they're at it. His testimony, even the way he comes across when he's on the stand, is very, for lack of a better term, smug. And it seems as if he thinks he's the smartest person in the room, and he wants to be in control, and he wants to manipulate the way the facts come out, even when they can't be denied, even when they're undisputable based on the evidence that's there. I think that he had a tough time connecting with the jury on any level because of his overall demeanor, but I think also that his story did not seem to make sense in light of all the evidence.
Andell, you bring up some great points there, and one that I really want to focus on is what you said, this manipulative character that he had, the way he presented on the stand. So that really fed into what the prosecution's theory of the case was and how they were trying to portray Jacob. So they wanted him to be a master manipulator, abusive. They had gone back through his past and had looked at the treatment of his partner that was ultimately going to be the victim in this murder for hire plot. So his demeanor didn't really help him. And interestingly enough, you brought up the fact that this is the stuff of a Lifetime movie. We heard a jailhouse phone call during this trial where he told his mom, I'd like Bradley Cooper to play me in the movie. So it doesn't really help with what you're saying. Exactly, connecting with the jury and that egotistical demeanor that he exuded on the stand.
It's all about him. Every step of the way, it's all about him. It's how he's presented. It's about him being in control. And you could see how that translated into the relationships he had, because this was not the first time he was accused of being in a manipulative, violent, domestic situation. So here we see him on the stand, and he's going through this plan and this plot. And then even looking at the lack of concern he shows for the girlfriend he had at the time who had taken her own life before the trial started. It seemed to be, well, you know, I don't really feel any responsibility for that. And of course, as his lawyer, you're not going to advise him to get up and say, oh, it's all my fault. But at least you would want him to show some concern, some empathy for someone that he was in a relationship with, he should have cared about. And the fact that she's now lost her life under the intense pressure that came from this prosecution and these charges.
Absolutely. And you know that those types of facts, those types of issues, those statements that he made, it's not lost on the jury. They're looking for that. They're looking for sympathy, empathy. They are watching, especially when you have the defendant actually on the stand, which, as we know, is a rarity in a criminal trial, because there's a lot of risk putting the defendant on the stand. One statement that he made, which we just heard before you came on air, Andell, was he said multiple times, and we know to the police officer, and he just admitted it, well, I guess I said that, survival was the most important thing to him, his own survival. Now, in interviews after the fact, in reports have indicated that the jury really was stuck on that, and I can understand why. Yeah. That's absolutely feeds into what you were saying.
Yeah, it's a me first mentality, and he displayed it at every turn. It's about me, and I don't care what I have to do, I'm going to protect me. He talked about his career, how hard he had worked, and he wasn't going to let the fact that this abuse case that was coming up get in the way of all the work he had done over 20 years, all the prestige and acclaim that he had acquired, and he was willing to do almost anything to protect himself, his own interests. That me first mentality, I think, is what the jury saw, and that's why they convicted him in less than an hour.
Absolutely. I mean, that was a quick turnaround on a verdict, which we're going to watch right now and then come back out and talk to Andell. Let's watch the jury convict in a very quick decision right now.
We've got it noted down on the court notes.
Okay, very well. Thank you. Please be seated. Mr. Gidley, has the jury reached unanimous verdicts on both cases? Would you hand those verdicts to my bailiff? Would the defendant please stand? As to cause number 1543813, State of Texas versus Leon Philip Jacob. Will the jury find the defendant Leon Philip Jacob guilty of solicitation of capital murder as charged in the indictment signed by the foreman of the jury? Cause number 1543812. Will the jury find the defendant Leon Philip Jacob guilty of solicitation of capital murder as charged in the indictment? All right, thank you. Maybe.
There you go. Guilty verdict delivered in less than an hour. Andell, let's talk about this. So first of all, you made a great point before. Now, we know the jury not so happy with his testimony. That was a primary piece that they used in order to convict him. But from a defense perspective, in a case like this, with the facts that you have, you didn't really have a choice. The attorney in this case didn't have a choice but to put him on the stand. He has to be able to explain why there was an undercover cop hired in a murder for hire plot. So obviously that fell short, but was there any other way?
There really wasn't much of any other choice, Misty. The defense lawyer, they had to deal with the case they were given. Without him testifying, the evidence was overwhelming. With him testifying, at least they had an opportunity to present an explanation that, look, you know, I may have said these things, I may have said this, I may have said that. I never said I wanted her killed. I kind of just wanted her out of the way until this thing blew over. So them saying I wanted to have her killed was obviously an exaggeration and an overstatement of the facts. We have overzealous investigators, people that are willing to go to the extent of faking murders, faking kidnapping. They're too involved in this process. And I think they took it a step further than I did. I think that's what the defense is trying to say, but it just didn't fly. And I think the demeanor and overall character of the defendant did not help them at all.
Absolutely. And I think that you made some excellent points there. The defense really didn't have an alternative, and they really can't do anything about the facts they're dealt. You deal with the case that you have, and you put forth the most vigorous defense that you can, and that's what the defense did here. Ultimately, the testimony fell short. We saw the verdict come down, guilty. But let's talk about sentencing, because that's a different aspect. So the guilt phase of the trial and the sentencing aspect. Now, the jury sentenced him to life in prison. The defense asked for probation.
Right.
Very vastly different sentences there. So what types of factors are going into the consideration of a sentence in a case like this where, look, the defense attorney is going to point out, yes, he's guilty, but the victims are still alive. There's these issues, mitigating factors. What are they taking into consideration when making that determination?
Well, I watched the interview of the defense lawyer when he was leaving the courtroom after the verdict was read, and I listened to him tell the reporter at that time, the fact that that he could get probation for this case, and about his prestige and his work as a doctor and other things like that. And I just thought to myself, I don't know if the jury's going to go in that direction. I think those things will actually work against him, because you would say he was smart, he was successful, he knew better than to do what he did, and he used his influence in the community, he used his considerable resources, he used his considerable intelligence to hurt and manipulate other people. This is not the type of person that we should have on the streets. Listening to an interview from one of the jurors, I think that's exactly what they thought. They said that if we give him this type of sentence based on not only this case, but his history of abuse, his history of manipulation, his history of this me first mentality, that we need to keep him off the street so he can't hurt other people, so he can't continue this type of behavior. This is a cold, calculated individual. These acts were intentional, thought out, and premeditated, and we don't need this type of person on the street. That's why they gave him the life sentence, and that's the sentence they came up with.
Absolutely. And you're right. All of those factors were considered by the jury, but look, they were not buying it. So probation, I don't think that was ever going to be an option. But now Leon Jacob will be spending life in prison. I think we're going to see, I'm sure we're going to see an appeal, because that's what a defense attorney will do under those circumstances. Whether or not there's any basis for it, only time will tell. But now I want to transition to the William Knight case out of Ohio, because Andell, we expect that case is going to be coming back live into the courtroom shortly. We heard the prosecution and defense opening statements. I want to play a little bit of the prosecutor's opening statements now and then break it down with you, Andell, because there's a lot of facts in this case, and I'm really interested to see how this unfolds. But here's the prosecution's theory of the case.
His daughter and his son-in-law went on a repo mission to recover a stolen dirt bike. And as things would go, as expected, there was a disagreement over that bike. The defendant was armed, he was ready, and he subsequently took out a .357 revolver, pointed it, pulled the trigger, and fired a bullet into the head of Keith Johnson, causing his death. A dirt bike. A Yamaha YZ80 dirt bike. It was a dirt bike that was owned by Curtis Gill. Curtis Gill was the son-in-law of the defendant. And actually the dirt bike belonged to Curtis's son. And back in 2016, around February of 2016, before this incident occurred, the bike got stolen. And they made a report to the Andell Police Department about the bike. There was no word, and nothing was heard about the bike for about 13 months. So we fast forward again to March of 2017. Curtis Gill became aware that that dirt bike, his son's dirt bike, had been put up for sale. It was put up for sale on an internet website associated with Facebook. And so Curtis Gill decided to go about the process of trying to retrieve the bike, contacting the seller, trying to arrange a meeting, and ultimately hoping to retain that bike. Now, the person who had put that bike on sale was a young man by the name of Justin Badgett. Justin did not own the bike. He had agreed to try to sell it for a friend, for an acquaintance of his, Keith Johnson. And the agreement was that Justin, if he was able to procure a buyer and have a successful sale, that he would get some money in return, about $100, like a commission for setting up the sale. They had no idea that the person who was expressing interest in selling and buying that bike was the true owner, the actual owner, Curtis Gill. Curtis Gill had seen pictures of that dirt bike online. He was convinced that it was his son's dirt bike, and he was correct. And so he went about doing whatever it would take to set up this meeting, using a false name, trying to do research about who was selling him the bike. And he also did the right thing. He contacted the Akron Police Department. And he told the Akron Police Department, hey, that dirt bike that I reported stolen about 13 months prior, I think I've located it now, and I want some help by the police. Night of March 20th, the police had a lot of calls. And they prioritized the calls as far as which ones they address first, which ones they go out to. And based upon the nature of this call, it was not a high priority. They were not able to immediately go out and meet with Curtis Gill. Curtis Gill was eager and anxious to get that bike. And although he hoped that the police were going to show up, he was willing to go forward for this meeting and not necessarily have the police present for everything that was going to go down, or have the police themselves take care of this, in which maybe there would never have been a meeting between Curtis Gill and Keith Johnson that night. Now, while Curtis was willing to go forward without the police being there, hoping they would be, he was not willing to go alone. He solicited the help of his wife, Michelle, and the defendant, William Knight. And they went over to that Dan Mead address in two different vehicles. Curtis Gill drove his black Ford truck. He went by himself, and he was in contact by telephone, with text and telephone, with his wife and the defendant, and they were in the defendant's red Chevy truck as they went over to Dan Mead Avenue. The defendant also had on his person concealed a loaded .357 revolver, loaded with 5 rounds. And this was not illegal, for the defendant had just recently obtained his CCW permit, his permit which allowed him to carry a concealed weapon. In fact, he specifically got that permit in January of 2017, about 2 months prior. And so unlike your average citizen, he had the right and the privilege to go through everyday life with a loaded gun concealed on his person. Now, having a CCW permit can give you a sense of empowerment. Having a loaded gun, life and death, right there with you at all times. But with it also goes a huge responsibility not to abuse that power. And in addition to that loaded .357, he had additional ammunition. He had what's known as speed loaders, 2 of those speed loaders. And a speed loader for this type of revolver contains 5 bullets each. And the idea is that if you shoot every bullet in that revolver, you can put all 5 bullets immediately into that revolver. You don't have to waste time putting in one at a time.
We're watching the William Knight trial out of Ohio. That is a replay from this morning, the prosecutor's opening statement, where they're laying out what they intend to prove in this case. So William Knight, he's charged with murder and felonious assault. He's being faced with the murder charges. The defense is going to argue self-defense, not self-defense of himself, self-defense of 2 of his family members who were with him on the fateful day when the victim, Keith Johnson, was shot. I want to bring Andell Brown in to talk about this, criminal defense attorney. Andell, I have a bunch of questions here because today was the first day that we really had an idea of where this case was going. There's been a lot in the media before this case hit the courtroom with respect to the charges and also to the theories of the case. So first of all, let's talk about some stuff that happened before the trial. Initially in this case, the defendant, William Knight, was charged with manslaughter. Later, those charges were raised to murder and felonious assault. What do you make of that? What was the issue? Was there a new fact that was discovered?
I'm not sure that there was a new fact, but as we know, criminal cases evolve over time. It may be new facts, or it may just be a new way of assessing the facts from a legal perspective. When he was initially arrested, as we all know, an arrest is a determination by the officers. The officers say, we believe that this is the crime that occurred. Later on down the line, the lawyers look at the case and they make the decision about what official formal charges they're going to file. and they can amend the information. That's what we call it in Florida, which is the charging document. They can amend it at a later point in time. Looks like that's what they did. One of the counts they had was actually felony murder, which is just that he was engaging in dangerous felonious activity, and while he engaged in that activity, he caused someone to die. So there are a number of different ways. It seems as if the prosecution was just covering their bases for all the possible facts that all the possible charges that the law would allow.
Right, and we saw the prosecutor lay out the case. They're very focused on the fact that Knight came to Johnson's house. He came there with a concealed weapon. He had a legal permit for the weapon, so that's not an issue for a concealed weapon. But basically, he came ready to rumble. This is all over a dirt bike that was allegedly stolen that they located through an online ad. And then Knight, his son-in-law, and his daughter all came to the Johnson household in order to retrieve the bike. Now, interestingly enough, before the trial began, the defense, it appeared, was going to assert an insanity defense. Right. And they've since retracted that. And now, and we will rewatch at some point throughout the day, the defense opening statement. The defense that's being asserted is self-defense. And another twist, it's not self-defense of Knight himself, it's self-defense of his son-in-law and daughter, who he said were under an imminent threat, so he had no choice but to use his gun. So let's talk about that, because to me this was a very interesting twist. An insanity defense is leaps and bounds from a self-defense defense. If you're talking about insanity, you're talking about the inability to know that what you're doing is wrong. If you're talking about self-defense, you're saying that you have the wherewithal to know that there's an imminent threat, and that because of that imminent threat, you were required to use deadly force. So can you break that down for us, Andell? I'm confused just talking about it.
Well, Misty, that could mean one of two things. Either his lawyers were grasping for straws, realizing that they didn't have much of a defense, and the insanity defense shows that they don't have a lot of belief in getting by with a self-defense case, or else they wouldn't go there, or that they're really brilliant, and this was part of their strategy to keep the prosecution occupied with preparing to go against that defense, and then at the last moment switching to a self-defense theory. That may be the case. I don't know which one it is. I'm not in on their, on their meetings and on their defense strategy, but it probably means one of those two things. Number one, it didn't seem like there was any real basis for the insanity defense. He was found competent, and they stipulated to the competency. They didn't even fight against it. It didn't seem like they had doctors or experts that would lead in another direction. So I really question why they did that. Now the defense is defense of another, and as you stated, we have more twists and turns. It's not I'm defending myself, I'm defending my daughter, I'm defending my son-in-law, and the 911 call, according to the prosecution, Mr. Knight said several different versions of that story. At first it was, well, I thought he was going to kill my son-in-law. Then it was, oh, I thought he was going to kill my daughter. Then it was, oh, I thought he was going to kill my son-in-law and my daughter. It seems like that story was all over the place when it all started out.
Right. The one piece that was consistent is, I guess, the fact that he had no choice. And a lot of that is going to come out as the trial unfolds. Of course, there's a hurdle here because the victim was actually fleeing when he was shot. So that is always going to be problematic when you're talking about self-defense. A lot of what is going to come out during the trial will be the placement, where everybody was standing, why an imminent threat was felt. There's going to be a lot of very fact-specific issues here. But I want to continue to watch the prosecution's opening so we can see the roadmap of where we anticipate their case going, and then we can talk about some of these issues in more detail.
Curtis Gill, he was in his black Ford truck. He had followed Justin Badgett to the area, and Michelle Gill, she was with her father, the defendant, in the red Chevy truck. Mr. Knight had pulled up, one of the last people to arrive, in the red Chevy truck, and when he came by the area where Curtis and Justin had parked, which was right in front of 797, he let Michelle out. Shell got out of the car, and then the defendant drove down the road, turned around, and got into a tactical position, a couple houses down, facing everybody, parked right by the fire hydrant that was pointed out to you. And that is a picture when police were called as to where specifically his red Chevy truck was located. To help you out then, here's an overhead view. This is Dan Mead, the street that you were just on. When Justin Badgett pulled up, he parked here. Curtis Gill in his black Ford truck had followed him and parked. Trying to keep these colors straight.
You have to put one thing at a time.
Gotcha. Parked right here. The defendant in his red truck parking in front of the fire hydrant. I keep making that same mistake up. Parked right here. Also important to note that there were two additional cars. Individuals who didn't have any association to either side, but these two cars were parked almost directly across the street, one after another. Right.
We're watching the prosecution opening statement in the William Knight case. This is a replay from earlier today. We anticipate court will be back in session, and we will be live in that courtroom shortly. The court was supposed to reconvene around 12:35. Might be a little bit later, but we will absolutely be back live in the courtroom once testimony commences. So we were just watching the prosecutor's opening statement, and we saw the prosecution going through a diagram showing the crime scene. Interestingly enough, the jury actually went to view that scene earlier today. Andell Brown, tell me, why is it important for the jury to go to a crime scene? We see it in some cases. It is something that both sides, one or the other side, might fight for, one might fight against. In some cases, both sides stipulate that it would be useful for the jury to go and see where this actually occurred. What's the relevance in this particular case?
The positioning of all of the parties is absolutely key. We've heard the prosecution's opening statement, at least portion of it. Previously, we've heard a little bit of the defense opening statement that was live, where he talked about the position of the Ford, I think it was the F-250 truck, being absolutely key in this case. Where the people are when this bike is speeding down the street kind of, really determines whether or not they're in the path, whether they're in a place where their lives could be in danger or not. I think also the position of the defendant's truck, whether or not he was actually just a bystander trying to protect his daughter and son-in-law, or he was actively trying to do self-help and be a vigilante by trying to block this person with his truck when that didn't work, firing off shots. I think those are the facts that are key in this case, and the prosecution and the defense are trying to use the forensic evidence of the scene, taking the jurors out there to prove their points.
It certainly is helpful for the jury to actually see where this occurred because, Andell, you're absolutely right. The positioning, where everyone was standing, that's all going to be critical to making a determination in this case. So in tune with that, I want to talk a little bit about what does it take to establish, from a defense perspective, self-defense of others. We're actually playing video from the on-site inspection with the jury this morning, so you can see the neighborhood, you can look at the street. This is what the jury saw today, so they're getting some context as they sit in the courtroom, and the defense and prosecution will both be using diagrams in order to show where everything happened, but they've actually been there, so it's going to be a little bit easier for them to picture if they have somebody come in and reconstruct what actually happened on that night. So, Andell, I'm just curious, the self-defense of others, now that is very different than the self-defense of just of yourself. And self-defense of others, in this case, you have the victim who's actually leaving the scene, and in the end is shot from the back. So there is a hurdle there, but what would the defense have to establish to be successful?
Well, the defense has to establish that they had a belief of serious harm or death for the people that they were defending, that the victim was causing those people to be in the proximity of serious harm or death by his actions, and that the defendant was just acting in a way to protect them from such. As you stated, the problem is that the victim at the time was fleeing, or at least that's the prosecution's theory. The defense says that he went up and then he came back towards them, quote unquote, and that he was angry as he sped towards the daughter and the son-in-law, and that's when Knight pulled out and shot those 2 shots, according to the defense. The problem that I see with that is we have a lot of people trying to engage in what we call self-help. They're trying to go out there and seize the bike on their own. They're trying to stop this guy from, quote unquote, fleeing on their own. When you have civilians that aren't trained to handle these situations, and someone who literally just got a carrying concealed weapon permit, that are trying to handle these dangerous and quickly unfolding situations, things like this happen. It's always best to leave law enforcement to law enforcement and not go out there and act in a way that can be determined to be vigilante. Here, Knight took a shot at somebody that looks like they were trying to get away, and I think he's going to have a tough time proving that what he did was legal.
I definitely think from the outside, and look, we have not seen all the evidence, so I try and maintain a bit of a clean slate. But when I first read the facts of this case, I said this is really going to be an uphill battle for the defense because of the fact that you have somebody who is leaving the scene. Now, according to the defense, the first shot was a warning shot. And it was at that point that the victim got on the bike and you maybe panicked, tried to get away. And then we don't necessarily know the exact placement, but as far as Knight's perspective and what the defense is arguing, he felt that there was an imminent threat to his daughter and his son-in-law. Now, what do you think is going to come of that? We're probably going to hear from the daughter and son-in-law. Does it matter if words were exchanged? Does it matter what the context was between all the parties? What facts are going to be critical here other than the placement of where everyone was standing?
Yeah, Misty, I think you hit the number one issue on the head, which is the placement. But I think also the context of the actions. I think the 911 call is going to be very key because it captures not only Knight's statements, but it also captures the daughter's statements at that time. And it appears that there was a difference in the tone and the recounting of the facts on that 911 call between what his daughter said and what Knight said. And it appears that the daughter was saying one thing, that Knight gets on the phone and tries to clean it up to make it into, oh, I was defending her, I was defending him, I thought they were going to die type of situation. Obviously, he knows he did something that could cause him to have to face prosecution. He's trying to make sure that he gets the narrative out there early that he was actually defending someone and not just trying to shoot someone who was trying to escape with a bike, which is obviously illegal.
That 911 call will absolutely be critical because any inconsistencies are going to speak to the credibility of the story of both the prosecution and the defense. But you're absolutely right. When you have inconsistent accounts contemporaneous when this happened, there's going to be a question mark in the jury's head. So we want to continue to replay the prosecution's opening statement while we wait for court to come back in session.
So that kind of sets the scene as to where cars were parked, where people were located. And it was at this time that when Curtis is there, or Keith is there, Keith decides to get the dirt bike out. It's behind his uncle's house. He brings it out. He drives up and down Ganymede Avenue just to show that it works. He would then come over to that driveway area, and him and Curtis would start talking about the sale. They're in the driveway, they're in front of the vehicles. And at that time, Curtis took out his phone and had a little flashlight on his phone, and he checked the dirt bike looking for the VIN number. He wanted verification that that was in fact his dirt bike. He got it. And at that point, he let the secret out. But this was in fact his dirt bike. He told Keith that it had been stolen and now he wanted it back. So to Keith, he paid money for it 3 months earlier. He didn't want to just give it back. He was resistant to that idea, and he asked Curtis, what can you give me for it? Curtis was either unwilling or unable to give him any money. It's at this point Justin Badgett decides, I'm getting out. He decided it was time to leave. One of the things that occurred while Justin was there is he realized he knew the Gills. Not only was he friends and associate with Keith Johnson, but he knew the Gills as well. And so with his green Civic, he pulled away. Keith Johnson also decided it was time to get out of it. He didn't want to give the bike back. Michelle, who was on the lawn in the close area, had called 911. And so Keith decided that he was going to leave as well, started up the dirt bike, and intended to pull away. Curtis grabs the dirt bike, trying to stop him. Keith is able to pull away, and it's at this point that the defendant, William Knight, has exited his vehicle. He's in the road, he sees some of these activities, and he fires a warning shot in the air. He's about 25, 30 yards down the road. Keith just wanted to leave the scene and maybe heard that gunshot, but in a panic he lost control of the vehicle. And when he left the area from that driveway, he almost crashes right into these vehicles here. The bike goes down. So now Keith is down on the ground with the vehicle, and this is what happens next. Curtis Gill wants the bike. He's not giving up wanting that bike, and he goes after it. Keith, he wants to just leave. He wants to get out of it. And so he doesn't stay on the ground, but he immediately gets up onto that dirt bike, tries to rev it. In doing so, the bike gets out of control. The wheel pops up from the front. His feet are on the ground. And the third thing that happened at this time is that the defendant, with his .357 revolver, doesn't fire another warning shot, never comes over to try to intercede in any discussions or to solve the problem, but it's at this time that he points his revolver straight ahead at Keith Johnson, aims for his chest, and ultimately hits him in the right temple. That bullet would go through his skull, would penetrate his brain, and he would go down immediately. No medical attention was going to help him. Keith Johnson died on the street of Andell. As I mentioned, Justin Badgett had left the scene. He actually had gone down the way toward what would be the dead end that you guys saw. We've had to circle back and go by everybody. So he didn't initially see the shooting. When he came back by, the shooting would have been accomplished, but he did not know exactly what was going on, and he left the scene. Everybody else, though, for the most part, remained. Police arrived. They began their investigation. They would find the defendant and his crew over by his red truck. The defendant had initially put the gun into his pocket, and upon talking to 911, put it down.
We're watching the prosecutor's opening statements in the William Knight case, which were live this morning. We're waiting for court to be live in the courtroom this afternoon after the lunch break, which we anticipate will be shortly. And we will absolutely be bringing you into that Knight courtroom the minute we have a live feed. In the meantime, we have Andell Brown here breaking down this case, which is heartbreaking when you really hear the prosecution talk about Keith Johnson's death. And we just heard the prosecutor say that Keith Johnson, the defendant fires a warning shot. Keith Johnson gets on the bike, is panicking. He wants to get out of there. And then the next thing that happens is that William Knight shoots him, and at that point kills him. Now, Andell, what I want to talk to you about is we've obviously heard that William Knight had a concealed weapon that he carried on him legally. And that he brought this weapon along with his son-in-law and his daughter to the Johnson house in order to ultimately retrieve this dirt bike. But does the prosecution have to show that the purpose of going to that house is come hell or high water, we're getting this dirt bike back? Or can they show that intent formulated at another time? What's the standard here?
They can absolutely show that intent formed at a later point in time. I think that the reason they're talking about him going to the house to go get this dirt bike is to kind of show the mindset that Knight came up with, the mindset that the other people came up with, that his actions of shooting at Johnson as he fled was in conformity with the mindset that was going on before. I think it just makes a cleaner story, a more logical theory. However, it's not the only theory that the prosecution can use. The prosecution can obviously show that maybe that's, even if they can't prove exactly that's how it occurred, that at some point Knight decided instead of letting this thing go, he was going to take it up a notch and use his firearm, and that's what led to the death of the victim in this case.
And yes, and that's very much where the prosecution is going. And as we know, intent can formulate in a second. I think you said it perfectly, Andell. That's what the prosecution is going for. That, look, there's the altercation over this bike. There's no agreement on whose bike this is. Johnson still wants money for it. They're not willing to give it. It escalates, and then ultimately William Knight decides that he's taking this matter into his own hands. Interestingly enough, you brought up that point before, the idea that this could be spun as some sort of vigilante justice. Well, reports prior to going into the courtroom indicated that the family had asked for law enforcement to escort them there, but ultimately, for some reason, the escort was unavailable, had another call, so they chose to go on their own. Does that factor into the case?
I think it does factor in. I think the defense is going to say they tried to do it the right way. But I think the counter from the prosecution is like, yes, they tried to do it the right way, but when they didn't get what they wanted, they decided to take matters into their own hands. I think it can go both ways, but I think the argument that after they tried that way and it didn't work, they took it into their own hands makes more sense when we look at the facts in totality.
Right. And there's another fact out there that I'm interested on your take, because it's one that I was grappling with as I was reviewing what was out there in the media before we were in the courtroom today and after listening to the prosecution and defense opening statements. There's this issue of, did Keith Johnson know that the bike was stolen? And there seems to be some indication that he didn't, that he had purchased the bike from somebody else, and that he was not part of the original theft. Whether or not the Knights believe that or not, we don't know, but that Keith Johnson may not have actually been the one who stole this bike from the family. But at the end of the day, does that really matter? Because with respect to the case here, even if Johnson did steal the bike, that's still not a justification for shooting him.
Right. It doesn't matter legally, Misty, but we know that trials and cases are often about more than the legal standards. And jurors are less sympathetic when they feel like someone is engaged in criminal activity than to a person who innocently may have purchased a bike. I think the amount of time that passed between when the bike was taken and when this incident occurs makes it very likely that he did not know the bike was stolen. That bike probably changed hands several times. Whenever people, steal property, they're usually trying to get rid of it very quickly. They're not just going to hold on to it for a year knowing that it's stolen, because that's the easiest way to catch a case. I think it would make more sense if we look at the whole picture that, probably someone sold that bike after they stole it for a few $100s to someone else, and now he realizes that he has something of value. He's trying to make a couple $100s himself. The fact that these people are selling this bike that's worth $4,000 thereabouts for a couple $100s probably means that either they got it from someone for not a whole lot of money, or they're just trying to get rid of it quickly.
Right, you're right, Andell. Whoever stole the bike, it's a hot bike. They probably want to get rid of it, get it through the chain of commerce, so it's less likely to get tracked back to the original thief. But you're right, from a legal perspective, it doesn't necessarily matter. But of course, the jury is paying attention to facts outside of just the strict legal arguments that us lawyers like to pick apart in the courtroom. Another issue that I would like to bring up, and I think may speak a little bit to the insanity defense now, which is not being raised in the trial. So we know that the defense is going to raise a self-defense of others defense of this case. But originally we did hear before the trial that insanity may be the direction that they were going in. So when you're talking about a self-defense case, you have to feel that risk, as the defendant, the risk has to be imminent, and it has to be reasonable for you to believe that, right? It's not just, oh, well, I personally felt that I was in danger. A reasonable person would have to feel that way as well. Does it matter if in some way the defense raises some, maybe not quite to the extent of insanity, but some lack of capacity that would make Knight more anxious than the average person or more fearful than the average person? Is that something that could come into play here?
They may try that. And Misty, I kind of call that type of situation the eggshell defendant, where they, we heard of the eggshell plaintiff in torts and personal injury law. And in defense, whenever you have a defendant that's asserting self-defense or defense of others, then you have to show, like, as you said, that what they were doing or way they perceived things was reasonable. When the defense attorneys try to inject, well, this person may have had some type of mental or physical condition that makes them more anxious, more concerned than the average person would be, I think that's problematic, because you cannot say, well, I acted irrationally because I'm a special person. I think we expect everyone in society to conduct themselves reasonably in their relationships with each other. So if it was not reasonable to use deadly force in that situation, if it was not reasonable to believe that there was imminent harm of death or serious injury to his daughter or another person, then the right thing to do would be to convict him in this case.
And I think that we're going to see those facts come out, Andell. And I agree with you. Those standards are there for a reason. It's to give a baseline of what would be reasonable behavior. You can't just say, well, I felt this way because I'm different. So I do think, though, we saw all these issues with the psychological evaluations. We saw a potential insanity defense, a question about competency. I wouldn't be shocked if something came into this case, and maybe it won't during the guilt phase, maybe it will come in and if there's a guilty verdict in the sentencing phase. I just wouldn't be shocked if we saw something about that, because to say that you're going to have an insanity defense and to kind of abandon it just seems like there might be more to the story, but only time will tell. Right now, we're going to continue to watch the prosecution's opening statement, which was live in the courtroom earlier today, while we wait for court to be back in session. And then we're going to come back out and keep talking about this with Andell Brown. Twists and turns everywhere in this case.
Police investigated, talked with witnesses. Ultimately, William Knight was charged in the death of Keith Johnson. Now, how do you know that the events of March 20th occurred as I just told them to you? Well, you will hear from multiple witnesses who were there and witnessed the events that evening. And to be clear, the events on Danmead Avenue are very short. This is not a long amount of time in which these interactions occur. You will hear that when Curtis and Keith are discussing the sale of the bike or the ownership of that bike, there's no yelling, there's no threats, there's no physical confrontation. And in fact, once Keith actually starts up that dirt bike with the intent to get out of there, to leave, the shot that would take his life occurred a matter of seconds later. You will hear about the police investigation. We talked about that a little bit yesterday, and the patrol officers would arrive on the scene first, make contact with the parties. A unit known as the crime scene unit, we call them CSU, they come and they process the scene. So you will see pictures of the scene after the fact. You will see a video of the scene. You will also hear from the lead investigator, kind of giving you an overall picture of that investigation. Finally, you also hear a 911 call. For when Michelle Gill showed up and was on that front lawn area, she called 911 when she learned that Keith wasn't willing just to get back the bike voluntarily. And she remained on that call throughout the shooting. So you will hear her narrative. You will hear Keith when he revs the engine up in an attempt to get out of there. You will hear the sounds from that dirt bike. And you will hear Michelle's reaction to what occurs and her description as to what occurs right then and there as it happened. And the defendant, William Knight, took over the phone. He got on the phone and talked to the 911 operator, and you will hear his voice, and you will hear him tell the 911 operator that the neighborhood is converging on the scene. He will admit that he aimed for the chest of Keith Johnson and shot. He will say he did so. His first statement that he did so is because Keith Johnson, or the person, was trying to kill his daughter. As the conversation proceeds, he will say, I did it because he tried to kill my daughter and my son-in-law. And as the conversation proceeds, he will then say, I did it because he tried to kill my daughter, my son-in-law, and he tried to kill me.
We're continuing to watch the prosecution's opening statement in the William Knight case out of Ohio. We're waiting for court to reconvene this afternoon after a lunch break. It had been quite the day in the courtroom with the jury doing an on-site viewing of where Keith Johnson was killed, of the scene of the crime, and also we heard the opening statements of both the prosecution and defendant. So we're reviewing the prosecution's opening statement right now, and we're here with Andell Brown, a criminal defense attorney, talking about some of the issues in this case. Now, Andell, I kind of want to talk a little bit more about what was going on before we ended up in the courtroom now. So there had been some, issues before we ended up in the courtroom. We talked about the assertion of the insanity defense, and now the defense is raising a self-defense argument. So there's that issue. Then we also talked about how initially the defendant was charged with manslaughter, and then ultimately those charges were raised to murder, felony murder, which what we see in the trial today. Now, a question that had come up in the community was, why weren't the son-in-law and the daughter also charged in some sort of conspiracy? And they were never charged, and there's no charges against them now. They're not on trial. I'm sure there'll be witnesses in the case, but is there anything that goes into making that determination when you have three people coming to the Johnson property to recover the bike? Ultimately, one person pulls the trigger, but we've seen cases before where there's accomplice liability. What makes or breaks that analysis?
I mean, you're absolutely right, Misty. That is a great question. And I think what usually makes or breaks that analysis of whether or not there was some type of agreement between the parties about what's going to happen there, whether or not they knew that Knight was armed and that he would use his gun to stop Johnson or whoever had the bike from escaping, or whether they had some type of agreement or understanding that they would use violence to retrieve the property that was allegedly stolen. I think that's the part that the prosecution would have to prove or be able to establish at least on a prima facie basis that there was some type of agreement between the parties. From the facts, it seems as if there were a lot of intervening causes, that maybe Knight wasn't originally supposed to be part of it. They called him later because they were going to use his truck, et cetera, that may have been the reason why they did not choose to file those charges.
Right, and again, the son-in-law and Knight's daughter were not charged in the case. That was from the community. It had asked those questions, but now as the case unfolds, we see why there were not accomplice liability charges levied against them. So we have a feed in the courtroom. We're going to go into the courtroom now. It appears that we just saw the judge on the bench, so it looks like we will have testimony. A witness is being sworn in. Andell Brown, thank you so much for joining us today. We really appreciate it. Stay tuned because we want to talk about this trial more.